So good afternoon. My name is Jason Hanford. I'm an attorney at Chartwell Law. I practice workers' compensation in Pennsylvania. And today, along with pretty much every other month, we started this in May, we'll be going through the end of the year. We're doing an overview course on Pennsylvania workers' compensation claims, handling of Pennsylvania workers' compensation claims. I'm going to be on all of those seminars. You can think of me as your tour bus driver. You don't have to give me tips, but I'll just be going along the journey with you. And each time we do it, we're bringing on two good-looking, smart experts who know what they're doing. And I'll do what my specialty is and ask them dumb questions, and they can explain complicated concepts. So that's our approach to this. If you're really excited about this one, our next one's coming up in September. I think we're doing claim petitions, defenses to claim petitions. This is a basics. It's an overview. It's how this stuff works. But I think it's been pretty useful. It's frankly been useful for me to refresh myself on stuff that I haven't worked on lately. And I learned a little bit about even course and scope today, which is our topic. We're talking about course and scope of employment in Pennsylvania workers' compensation claims. So a few housekeeping items. If you have questions, we love questions. I would only ask that when you do have a question, put it in the Q&A section. It'll be at the bottom of your screen. For me, it's all the way on the right-hand side. You just click on there, put a question in the Q&A. You can put stuff in the comments, but it's in the chat session, but it's a little harder for me to find those. That's better used to make fun of my hair or do something that's not specifically a question for us to address. What I will do today, what's a bit of a change, and I was talking with Chris and Rob about it, I think I'm going to try to take most of the questions at the end. With course and scope, there's a lot of different fact-specific scenarios, and I suspect that if we start on one area of course and scope, somebody might have a question that pertains to the next area that we're going to be covering in 5 minutes. So put your questions in as they come up. We'll probably get to most of them at the end. This presentation is being recorded. So if you have to jump out, or if you want somebody, if you think it's just fantastic and you want somebody else to see it, we'll be sending out that video. We'll put it on our YouTube channel, social media. You can like it and share it and all that good stuff. The typical disclaimer we always give is we are lawyers. We're, for the most part, pretty good lawyers. What we're doing today, we're not providing specific legal advice. Even when you ask us questions, we'll give you the best answer we can, but please don't go make bad decisions based on what we thought you were told. If you have questions, we're happy to represent you. We probably already do represent a lot of you. All of that housekeeping out of the way, I want to present to you my co-presenters. I'll let them introduce themselves, but before I do, Chris and Rob. Chris is in the Scranton office. He heads the Scranton office. Rob heads the Harrisburg office. Gentlemen, we have worked together for almost 15 years. I looked it up. So I know these guys well. They do excellent, excellent work, fantastic attorneys, and the clients really love them. So it's a really good opportunity here to hear from people that know what they're doing. So Chris, do you want to go first? Just say who you are and what you do.
Absolutely. Good afternoon, everyone. Chris Pavuk here. I work out of the Scranton office at Chartwell, and I would say about 90 to 95% of my practice includes representing employers, insurance carriers, third-party administrators in Pennsylvania workers' comp. I also dabble a little bit in federal black lung work, which is pretty much similar to the workers' compensation side in Pennsylvania. I've been doing this a little over 20 years, and I enjoy what I do. So I'll hand it off to you, Rob.
Hi, good afternoon. My name is Rob Baker. I am in the Harrisburg office. I handle Pennsylvania workers' compensation matters, general employment matters as well, including human resources, litigation, OSHA, things like that. And I also handle Virginia workers' compensation. I've been with these gentlemen for a number of years, practicing a few years less than Mr. Pavuk.
And Rob also enjoys what he does. He told me before. It's no secret.
Very much so. I forgot to mention that. I'm happy to be here.
Chris, do you want to, I think we should just jump in because we've got some detailed stuff to cover. I don't want to take too much time. Do you want to give everyone an overview on the standard as it is? I know it's as we'll talk about, it's very fact specific, but what are we generally talking about in Pennsylvania for the course and scope issue?
So, I mean, after we establish that there is an employment relationship, there's an employer-employee relationship, the next thing that we need to look at, and sometimes we take for granted, is was the injury within the course and scope of the employment. And the question that's asked when we get to that is, was the employee injured while actually engaged in the furtherance of the employer's business or affairs? So that's the ultimate question. And the test for course and scope of employment was outlined in the court's case in Schlagenhut versus U.S. Steel Corporation. And I will read you, the court in that case set forth a test that we apply, and there's several parts to the test. And we will break that down for you today, part by part, but that's essentially what the courts look at and utilize as the standard of review to determine if someone is or is not within the course and scope of employment. So what the court outlined was injuries may be sustained in the course of employment in two distinct situations, where the employee, whether on or off the employer's premises, is injured while actually engaged in the furtherance of the employer's business or affairs, or where the employee, although not actually engaged in the furtherance of the employer's business or affairs, is A, on the premises occupied under the control of the employer or upon which the employer's business or affairs are being carried on, B, is required by the nature of his employment to be present on his employer's premises, and C, sustained injuries caused by the condition of the premises or by operation of the employer's business or affairs thereon. That's a mouthful. There's a lot going on there. We're going to break that down for you as we go through this. As Jason indicated, these cases are very fact specific. So as far as a practice tip goes for the insurance carriers, the insurance adjusters or employers that are on this this call, remember that taking notes, getting witness statements, memorializing the factual scenario behind the injury is critical if this ultimately goes into litigation, because Rob and I and Jason are going to need to present employer witness testimony, and that is what these cases are going to turn on. So it's really critical that the more documentation you guys can memorialize in writing, the easier it is for us, because you know the way this works. It could be months before we present testimony at a hearing before a judge. You know, memories fail. It's important that we get that down in writing. Witness statements are critical. So at that point, I'll hand it over to Rob to talk about the premises aspect of the course and scope standard.
Yeah, I just want to jump in for a second as I step on Rob's toes. I apologize.
That's fine.
I agree with that point. I think it's really a salient point from Chris in that sometimes we, the attorneys, the defense attorneys, will get to that first hearing where the claimant's testifying. It's often by deposition now. And an issue will come up during that testimony that really hadn't been flagged earlier in the claim. And when we can go back and you already have your interviews, you already have your adjuster log notes, you already have all the stuff that documents what the claimant said when you first interviewed them, it's an incredible help, because it's really hard to go back and recreate that, whether it's for a course and scope issue or for any other issue that affects the defense of the claim. The second thing I had was Schlagenhop. That's a good pronunciation, Chris. It sounds like a beer or something.
I was going to use my German accent, but I decided I'd spare everyone.
Yes. So you mentioned that from the definition, and this goes to Rob, from the definition, the first part was on or off the premises. So what are we talking about with the premises there, Rob? How is that defined further?
Right. So Chris had touched upon the premises definition. Is it occupied by the employer, under the control of the employer, or was the employee required to be on that property or premises to further the business affairs, the employment relationship of the employer? You know, a good example of that is really one example is if you have a grocery store employee who works at the grocery store but is doing personal shopping. So that factual distinction would be really important to determine whether the employee was furthering the employee's affairs. I just wanted to mention too, you know, Chris had said these types of cases are all very, very fact specific. So getting back to the importance of the documentation in this, the fact pattern I provided, the detail of what the employee's job duties are, when the employee may have clocked in and clocked out. Are there rules or procedures that address personal shopping of the grocery store employee at the store during work hours, or is it limited to non-work hours? Those types of details would really be very important to determine if there was an exception that we could address. The required by the nature of the employment on the premises, that one I think is, we'll get into it in a bit with Chris, is interesting because there are a lot of employees that may be stationary, but there are also many employees that are not stationary, where they don't have a fixed place of employment and may be traveling. So that is, in a nutshell, the premises prongs for control, occupation, or required to be on, at that location.
And then I saw another notes that I don't think it was from Schlagenhop. I don't have the German pronunciation, but it's something we see a lot. Statutory employee, traveling employee. Obviously, in the post-COVID world, everybody's working from different places now. How is that addressed in Pennsylvania case law, whether you're a traveling employee, statutory employee, Rob?
Yeah, so the stationary employee is easier. That employee would report to a workplace and work in that location each and every day. In fact, probably many of the people that we're talking to were stationary employees pre-pandemic at a fixed office location. The other side of that is a traveling employee, where that employee doesn't have a fixed place of work. There's a broader definition of course and scope. So in other words, when the employee were to leave the house, they may in fact be on the clock or within the course and scope of employment. Examples might be traveling salesmen. Oftentimes the plumbers or electricians might be dispatched from their house. Home health aides, home nurse aides, those types of positions. And I think to take that one step further, the blurring of the lines between employment and not being on the clock, I think has been exacerbated by the pandemic, with so many people working from home. So a lot of times I'll get questions of, if I'm upstairs in my pajamas eating, my toast and drinking my coffee before work, but I walk down the stairs to my home office and I fall down the stairs, is that within the course and scope of employment? And I think, it gets back to, what we all like to say is it depends, and what are the specific facts of the case.
Yeah, and I think, Rob, even within those, and I apologize, I said statutory employee, even between stationary employee and traveling employee, it would be easiest to just label the employee as, Rob's a stationary employee, that's what he's going to be for life. But as we know, it can change. I mean, you could be a workers' comp defense attorney who typically works out of a stationary location, but on occasion you're traveling to hearings or you're traveling to depositions. It's very job specific, and I think that's what makes these cases so interesting, is that you're not going to see them all the time. I mean, you're not going to have a course and scope issue in every single claim petition you get. You're probably going to get it somewhat rarely. When you do, they're always complex. I think, and you guys can weigh in, but I think the injuries are always somewhat bizarre. It's rarely a back strain. It's always somebody, happened to step off to get a coffee and they're hit with this catastrophic injury, and it really makes for some difficult litigation. Chris, coming and going rule, if we're talking about a stationary employee, how does the coming and going rule apply typically, and are there exceptions?
Yes, so the coming and going rule, if you don't know, involves your commute to and from work. So generally, and from a general perspective, commuting to and from work is not within the course scope of employment. So if you're a stationary employee, you get into an automobile accident on the way to or from work. If you were just going straight to work or coming straight home, and you're a stationary employee, that is not going to be a compensable work injury. You will not be considered within the course and scope of employment. There are exceptions. Again, traveling employees, as we indicated before, you're on the clock the minute you step out of your front door and you get in your car and you start going. So obviously, if you get into an automobile accident, you get injured as soon as you walk out the door, that's going to be a situation where the coming and going rule does not apply. The next exception was employment contracts includes transportation. The case law on that has been relatively clear that the employment contract must include a provision for including commuting. If it is silent or specifically excludes that, then the coming and going rule can apply that it is not within the course and scope of employment. So you'd have to, again, if we have a case where these are the facts, then the attorneys want to see the employment contract, and we're going to be presenting evidence to the extent that the employment contract supports a position that it does not include commuting in support of our defense that this is not within the course and scope of employment. Obviously, if it does include that, the case law is against us, and we need to look to see if there's any other reason or basis that we can continue with the defense of the claim. So again, fact specific in that situation, there's going to be documentation that we need to look at, review, produce to the other side, and litigate that issue. Another exception to the coming and going rule are special assignments. That's typically a situation where you have a stationary employee where their boss tells them, hey, I need you to go across town to pick up something from someplace or do something. It's a stationary employee typically who is almost turned into a temporary traveling employee. So if something happens and they are on their way to or on their way from this special assignment or special mission, any injury that's going to happen is likely going to be an exception to the coming and going rule and be compensable. Again, if there's any abandonment or the person while they are on that special mission does a personal errand, that's something that we would litigate as well, and we would need to present evidence that that happened and that they abandoned their special mission. But ultimately, special assignments are an exception to the coming and going rule. And the last circumstance that we see occasionally is if someone is commuting to and from medical treatment for what is an acknowledged work injury. If they get into an automobile accident on their way to physical therapy and they sustain new injuries or aggravation of those injuries are compensable under the original work injury. And we would have to pay for medical treatment and potentially disability benefits under those circumstances, assuming there's no other extraneous reasons why this happened. So,
Chris, just to flesh those out for a second with a question, special assignment, would that be, I brought up the example, I selfish attorney only thinks of himself. I'm headed to Lansdale for a deposition. As opposed to going to the office, I travel directly to Lansdale for the deposition. That falls in most likely to the special assignment category, would you think?
That or your, I mean, as you indicated, we're kind of hybrids in what we do. You might be considered a traveling employee at that point, but I would think that would fall within the exception of the coming and going rule and would be compensable.
And then you mentioned departure.
I'm sorry,
go ahead, Rob.
Take that one step further where you're traveling to Lansdale for your deposition, but you stop at the rest stop, get a cup of coffee, use the restroom, you injure yourself in that time frame. I think then it becomes an issue of abandonment, right? Of was that a distinct break from what you were doing, or was it so minor, momentary, and significant that you were still within the course and scope? So those are the types of things that I think come up quite a bit too with these special circumstance traveling employees.
And I think that kind of leads into our next topic, Chris. We have furtherance of employment. So I think that kind of touches on what Rob's getting at there.
It does. And one last point that I wanted to make, because it's something that would see, there's case law that says the mere permission to use a company vehicle is not enough to establish the contract to include transportation. So we see a lot of times where an employer will just allow somebody to use a company vehicle to go to and from work, but that's not enough if they seem to get into an accident with that company vehicle. So I wanted to just throw that out there as well. Yes, actually engage in the furtherance of the employer's business. So some examples that would meet that standard is a motor vehicle accident after stopping for dinner while traveling from a construction site to obtain supplies and drop off a coworker. So this would be a situation akin to what Jason and Rob were just talking about. We have what would likely be a stationary employee typically, but he has to go to a construction site to obtain supplies and drop off a coworker. And during that time, he stops for dinner. So the court in that case said that that is still within the course and scope of employment because it was not a situation where there's any job abandonment. There's not sufficient break from the duties that would further the business affairs of the employer. So that's probably as far out as we would get. And again, these are situations where, depending on the judge that hears the case, there is adequate case law out there that case can go the other way as well. And we have to be mindful of that there is case law on both sides of these issues to support either side. The next case is probably the most highly cited case in course and scope cases, and that's the Ryan Stairs case, Baby Room versus the WCAB Stairs. This was a sad situation. We have a claimant that was a furniture delivery driver for a children's furniture store. They were on their last delivery of the day. They had delivered the furniture. The coworker was at the front door having the customers sign off on the delivery. In the meantime, the claimant, Mr. Stairs, innocently ran. There's a basketball hoop in the driveway, jumps up to touch the rim of the basketball hoop. His feet go out from under him. He falls down and sustains a traumatic brain injury. Ultimately requires a life care plan, almost becomes a vegetable as a result of this. So the question was this an innocent temporary departure, or was touching the rim, did that further the business affairs of the employer? The courts held, and the Commonwealth Court held, that it was an innocent temporary departure, and it did not remove him from the course and scope of employment, and the claim was found to be compensable. And the courts indicated that temporary short departures, intervals of leisure are common during the workday and would not remove somebody from the course and scope of employment. I think in large part the courts found that this was a compensable claim because of the severity of the injury. That can't be discounted in this case, but ultimately this is the case law, and this is the case that you see cited in the judge's decisions and cited by claimant's counsel when we're dealing with the course and scope. So this is the case that we need to overcome when we're dealing with these issues, when we're dealing with the momentary or temporary departure from course and scope of employment. So some other examples are injuries where someone was walking to the bathroom. Those are what we call the personal comfort doctrine. That would not take them out of the course and scope of employment. And the one that frustrates, I think, all of us, there's the case out there where an individual sneezed while at work, and because they tried to hold the sneeze back to not get the fellow employees sick, it was deemed to be a compensable work injury when they sustained an eye injury in holding back the sneeze. So that's how far the courts are willing to go in these course and scope cases. And again, these are strongly factually based. We need to make sure that we understand the facts of every case.
Yeah, I think, Chris, that last case takes on a different view in light of COVID. And I think, frankly, to be honest, and it sounds like a silly case, but I think in the current environment, it'd be even more of a slam dunk for the claimant in that case. And when I look at these cases, and Rob's going to give us some examples of actions that were not found to be in furtherance of the employer's business, they always sound the same to me. Sometimes the examples of what's not in the furtherance of business really don't sound drastically different than what is in the furtherance of the employer's business. I've always explained it to clients as, the U.S. Supreme Court obscenity standard of you'll know it when you see it. I think that's kind of what it is here, only the you who knows it when they see it is an individual judge. And it could be a judge who loves basketball and every day of their life, if they saw a basketball rim, they jump up and touch the rim. Or it could be a judge who hates basketball and you get a different outcome. It's very specific on the facts and the fact finder. And I think Chris has a good point. If you have a situation where the claimant is a sympathetic claimant, it starts to stack up the deck against you. But Rob, why don't you walk us through some things that the court came down and said, no, that doesn't count. That's not in furtherance of the employer's business.
Sure. Yeah. So one example is when an employee intentionally jumped down a flight of stairs while on an unpaid lunch break. We were talking about this a little bit prior to today's presentation, and that is not initially, first review, all that dissimilar from the stairs case where the gentleman was injured by jumping up to catch the hoop. I think that distinction, though, is as I understand stairs, he was still on the clock, right? He wasn't off the clock, but the cases involving people jumping down flights of stairs or injuries similar to that when they're on an unpaid meal break, I think that is one way that the courts have handled it. You'll know when you see it type distinction for not being in the furtherance of the employer's business affairs. I totally agree with the two of you that a lot of these cases are, we'll probably say it until we're blue in the face today, fact specific, but also if you have a sympathetic claimant, that is going to help, I think, on the claimant side. But if the claimant doesn't present well and there's a fact in this case, in this situation, the claimant was off the clock for the unpaid break, I think that those go to our favor as well to make that distinction. Another example, and this gets into a little bit about parking lot premises and things. If there's an employee that is crossing the streets or the highway to obtain a personal item out of the car in another parking lot or parking garage or on the street, and the individual is injured, whether it's struck by a car or twists the ankle stepping off the curb, that necessarily would not be within the course and scope in and of itself, unless, of course, that item was in some way needed for completion of work assignment. And if we're talking COVID environment, the one thing that I come to my mind when I was reading and preparing is if somebody needed their mask, right, and they forgot their mask and they walk across the street to get the mask because they have to mask up, or they're in the nursing home or if it's an office requirement. I could see in today's environment how a judge might say, oh no, that is work related because of the masking requirement. But pre-COVID, simply retrieving a personal item out of the car, whether it's a purse or a cell phone or something to that effect, would not necessarily place it within the scope of furthering the employer's business affairs.
Rob, can we talk about, it's one of the hallmarks of personal injury law. We have the fender benders, and then we have slip and falls on sidewalks or parking lots. It keeps a lot of plaintiffs' attorneys in business. It keeps us in business. So how does that work? If I'm at work, I'm going out to my car in the parking lot, I have a slip and fall, is that going to be a comp injury on the usual? I know it's very fact specific, but what's the standard there if there is one?
Yeah. Sure. So, the first thing that we would want to look at is, in my mind, the control of the premises, the parking lot. So if the parking lot or the road from the highway to the location is under the control of the employer, those types of slip and falls would likely be compensable. If, however, the employee can park, they're not required to park on the company parking lot, or they can choose whatever parking garage they so choose and walk to work or across the street. If the employee were to slip and fall, say in the parking lot that is publicly owned across the street, I would make the argument that that was not within the course and scope or furtherance of affairs, because the employer had no control over those premises. If the employee is leaving work for lunch or going to their car for a paid break, those types of things would generally be looked at as compensable. Again, if especially if the employee isn't permitted to leave the premises during the paid break, and or if the premises are in some control by the employer. So if the employee, even if the employee is clocked out and they're leaving the office to go to their car for lunch, they slip and fall, that theoretically could be compensable if it's under the control of the employer. I think we've all had cases like this. Years ago, I had a case where an employee was required to park in the nursing home parking lot. The employee decided not to walk around the cleared sidewalks, but instead chose to climb over a 12-foot snowbank. Employee fell, injured her leg and knee pretty badly. That was ultimately deemed to be compensable because of the control of the premises, the parking lot, by the employer. Another example, same type of situation where the employer owns the parking lot, an employee clocks out for the day or hasn't even clocked in to start work, and they get out of the car and they slip on black ice, fall and suffer a head injury or back injury. Those types of fact patterns would be real world examples of something that's compensable.
Yeah, and I think clients should be aware that sometimes these course and scope issues intermingle. We're going to talk about violation of a positive work order later. Sometimes you'll have a violation of a positive work order that sort of overrules what might be, from a course and scope perspective, looks like, okay, they should have been there, they should have done that. I've had in the past, I had a claim where the claimant, Chris mentioned contract for transportation. In this instance, the contract for transportation was a bus that was made available to the employees at a factory where they would park at a specified parking lot. Bus would pick everybody up. That was the only way to get to the factory. When they got off the bus, they got off onto public property. It was essentially a smaller public parking lot. So you have your employment contract for transportation, you hop off the bus, you slip and fall in the public parking lot. It brings up essentially two course and scope issues in one. So it's, like I say, these don't come up in every claim, but when they do, they can be pretty interesting. Chris, let's talk about some fun stuff. In the post-COVID world, we're eventually going to see each other face to face. I want to have fun. I want to go to company picnics and be a bad softball player and do all those fun things that we at Chartwell love to do when we get together. Something horrible happens to me. What's the standard? Can I get a comp check out of it?
Well, much like the parking lot cases, again, it comes down to the level of control of the employer. So level of control, the involvement of the employer, the direction of the employer. So we have a softball game that you're playing in. The question is this a Chartwell sponsored softball game, or is there just a couple of Chartwell people on the team? That's what makes the difference. Some examples of compensable injuries under the social athletic activities that we see. A police officer was injured while running to keep up with his employment requirements. That seems pretty obvious, right? An employer-run gym on the premises. Employees are encouraged but not required. A lot of employers have gyms on the premises. You can see this case coming down to the argument of whether or not it was encouraged but not required. You can just imagine the testimony of the witnesses on that and how that was vocalized from the employer to the employees. And that, that's got to be a difficult decision from a judge. And we can, again, depending on what judge you have, that can come down either way. Again, like we indicated before, softball games, company-sponsored team, If it's a company-sponsored team, it's going to be compensable. You know, we used to, I think Rob and I used to play on a volleyball team with the Bar Association in Harrisburg for years. You know, there's a question.
Firm
sponsored, by the way, right?
Yeah.
Do we have any video of that, guys?
Yeah.
Some highlights we can put with the
Thank
YouTube
God,
of this?
no.
No, that's like, I'm not going to say that we won the championship, but we did. And, you know, it was just a bunch of guys getting together under, you know, the name of our firm. So we did it. And I don't necessarily think that it was firm, you know, it was firm sponsored. So if someone got hurt, you know, my argument would be it would be not within the course and scope of employment. It would not be compensable. But again, that would be for a judge to decide. Company-sponsored picnics, that seems pretty obvious that if someone was injured there, then it would be work-related. Again, question would be, traveling to or from this company-sponsored picnic, would that be work-related? Coming and going rule, we would make the argument that the coming and going rule would apply if you're a stationary employee. Some examples that are not compensable, traveling to a family day picnic instead of reporting to work. And another example, encouragement to participate in police Olympics, not within the course and scope of employment if the event is not sponsored by the employer. So again, the critical aspect of this is the level of control and the direction of the employer. And that would be the factual evidence that we would be presenting to support the fact that it was not within the course and scope of employment.
Yeah, it's tough. I mean, these things can get ugly because, you know, I think all employers want some good mental and physical well-being for the employees. They're having picnics and softball teams and doing all this stuff because they want to have a good, strong, happy workforce. And when something happens here, it's you know, all the people on the call on the conference know that the work injuries put drive a wedge between employees and employer. And that's just a typical work injury. That's just I strained my back lifting something on the loading dock because that's my job. Now I'm here with my family and my kids hanging out with Chris and Rob, and I choke on a chicken wing, and all of a sudden we're fighting over whether it should be compensable or not. So it can be tough, but I think, again, it's going to depend on the judge. I mean, to differentiate between getting injured at the company sponsored picnic and getting injured while traveling to the company sponsored picnic is just, it's interesting. It definitely must have been a different judge. But Rob, I touched on briefly, and I know you were going to go into more detail, some of the, I guess more of using course and scope, I'll put it this way, as more of a sword than a shield, where we can use it to try to bounce a claim, whether it's violation of positive work order, you know, violation of law, those sorts of topics. Can you explain to everybody how that works? It's obviously different than what we've been talking about so far. It falls under this umbrella, and I think it's important.
Sure. Yeah. So there are certain affirmative defenses that we can raise. Defenses to the claim, saying, in course and scope issues aside, even if there was an injury, certain facts may support themselves to deny the claim in its entirety or to argue against the denial. The first is a violation of law. If the injury results from a violation of law that would be a misdemeanor or felony level, that would be a defense to the claim, opposed to a summary offense. So if somebody is injured because they're speeding, and the offense would be a summary offense ticket for speeding, we wouldn't be able to raise the violation of law defense. But if somebody was injured while driving and they would or are cited for a misdemeanor or a felony as a result of operating the motor vehicle, that would be a basis to deny and defend the claim on the denial of the entire claim. Violation of positive work order. This can be somewhat difficult to prove. Essentially, if the injury was caused by the violation of the positive work order, and the employee knew of the rule, and the rule was implicated in the activity that the employee was doing, that might be a basis to defend. So, for example, if I am a equipment operator making widgets, and my widget machine keeps jamming, and rather than turn off the machine as I've been instructed and Ideally, the rules would be in writing, and there might be shop box talks, the safety talks on the floor. And I elect not to turn off the machine, but rather I cut a hole in the safety guard that allows me to unjam the machine while it's still running. One would think that that would be a positive work order violation where a judge would deny the claim. That is actually a true fact pattern, and the judge did deny the claim, but ultimately on appeal, the appellate courts found that there was a work-related injury and a partial amputation of the finger, because the court said, oh, well, no, the employee was actually trying to increase efficiency. Now, keep in mind, they get paid by piece rate, but they were trying to increase the efficiency for the employer, and that was furthering the employer's business affairs, and there wasn't a violation of a positive work order. So those are some of the factors that you look at. I will tell you that when these affirmative defenses arise, even if ultimately I think that the judge might rule against me on, say, the positive work order violation, I still raise it, especially if it produces an opportunity where we can try to resolve the claim less expensively or more expeditiously by using the defenses. And I always raise them, because if you don't raise them, then you waive them. So it's better to have the judge rule against you than not raise it at all. Personal animosity, this occurs when the injury is a result of a personal reason between two people, whether it's two employees or an employee and someone else. It's not the employee. If the disagreement was solely for something unrelated to the completion of the work or the assignments, then that would be an affirmative defense. An example, I had a case years ago where two gentlemen, their job was to repair and replace coin-operated washing machines and dryers. They were at one of the locations on the second floor. The two gentlemen started to have a disagreement over one of the gentleman's lifestyle preferences. He was married, and I guess he had a significant other in addition to his wife. So when they were removing one of the dryers, the gentleman that didn't like that lifestyle dropped the dryer down the stairs onto the employee. The employee obviously was pretty injured when the dryer landed on him. But ultimately, we defended that claim under the personal animosity defense, because we were able to establish that the sole reason for the injury was because of the disagreement between the two over the claimant's lifestyle. So that's always if you get those fact patterns, they're always lots of fun. And then lastly is intoxication. If the use of illegal drugs or alcohol results in the work injury, you can raise a defense that the injury was caused in fact by the intoxication. This can be difficult because the mere test that shows the existence of drugs or alcohol in the system and not necessarily the level of intoxication is insufficient. When I have these cases, I've had them successfully defended where the employee might be unfortunately seriously injured, but at the hospital there was a blood test that was run, and the tox screen showed the levels of the substance of each substance in the bloodstream. You can use that test through a toxicologist who can then determine, basically by reversing time, at what level of each substance the employee had at the time of injury. So if you have the blood test rather than a simple urine test, that is really, I think, great evidence that you would want to have reviewed and report generated by a toxicologist.
Yeah, Rob, just a question on that, and I think it's a common question. Is it, you mentioned causation. You have to prove that the intoxication caused the work injury. It can't be that the claimant had a level of something in their blood and they had a work injury. It's not just a correlative situation. You have to prove actual causation.
Correct. but for the intoxication, the work injury would not have occurred. I had a case, the gentleman worked in a scrapyard. His job was to cut big pieces of steel into smaller pieces of steel using a big circular saw. And the gentleman, the saw jammed. The guard fortunately covered the saw, but it kicked back and struck him in the middle of the forehead. So he had an injury down his face. He was severely injured. He went to the ER. At the hospital, they conducted a blood screen, and he was severely intoxicated with alcohol. He had cocaine in his system. He had prescription medications that weren't prescribed to him, all at levels that individually he should have been incoherent and passed out. So I used that screen through a toxicologist to prove that there was no way this gentleman could be performing that manual type of job in his situation. And the judge had found that because of the levels of his substance use, that was in fact the cause of the injury.
Yeah, and Rob, I think you raised a really good point in that I think it's good to raise these issues, even if you think you might lose on the violation of the positive work order or on animosity intoxication, because it highlights an aspect of credibility for the claimant that might help you out elsewhere in the decision, whether you're talking about the length of disability or the claimant's testimony about pre-existing conditions. The judge takes everything into account as a whole when they're judging credibility. So I think flushing out this evidence does nothing but help the defendant in proving other issues.
Yeah, in my opinion, we don't. I think we rarely win on medical expert versus medical expert. We do when the facts are right, but in my opinion, if we can address credibility piece by piece of the claimant, that is also very helpful. And if nothing else, Jason, if you're raising these defenses and the judge rules against us incorrectly, that's an appealable issue. But if you didn't raise the arguments or the defenses during litigation, you can't make that argument on appeal.
Chris, can I ask you, do you have any good intoxication stories, or did you have any input on any of these factors? I guess would be a better way to place it. But if you have intoxication stories, we can go there too.
Yeah, I've had some intoxication cases. I had one where the claimant was injured, went to the emergency room, and had high levels of, I think it was meth, but maybe some other things. I think and his father was in the emergency room with him and was denying any of this, and then pulled the nurse aside and admitted that he was snorting crushed Percocet before this injury happened. And unfortunately, we had an employer that was friends with this guy and didn't want to get rid of him. So ultimately, I believe that the case resolved for a small amount of money because of the strength of our intoxication. We presented the nurse. The nurse was very gung-ho to testify in this case because he was outraged about the drug finding. So we were able to find a witness that ultimately gave us the basis to resolve this case for just a nominal amount of money and not take the case decision when we had significant injuries. This was a big truck that was rolled over and we had significant injuries, but we were able to get out of it relatively reasonably because of the intoxication defense.
I think it's important to, I'm sorry, Jason, I just wanted to add, I think it's important to distinguish these types of intoxication defenses versus somebody who merely tests positive on a urine test for marijuana. That is not sufficient to establish an outright denial for intoxication. And I think that even becomes more complicated in Pennsylvania because we have the Medical Marijuana Act, which if somebody has the MMA card and they test positive, that even further muddies some of the other defenses you could raise for a positive drug test and working on site. So I just wanted to say it's an important distinction that somebody simply tests positive because they smoked pot within the last 30 days or whatever, that's not going to be something that rises to the level for us to say that they were intoxicated at the time of the injury.
Yeah, I think, and that's kind of what I was going to get to, Rob. I think all of these, you talked about 4 different sort of departures where you can use it as a sword to bounce a claim. We've got violation of law, violation of a positive work order, personal animosity, and intoxication. Taken at name value, they sound pretty juicy. You're going to be able to get a lot out of them. But as we talk about them, we see that intoxication requires evidence on causation. We see that personal animosity isn't just, I'm mad at my coworker because he took my overtime shift. That would be animosity, but that's not the personal animosity that's required. We see that violation of positive work order in particular, I think should be referred to as violation of a concretely communicated and thoroughly understood instruction, because positive work order makes it seem like Chris just once, offhandedly said, hey, don't ever pick up that book over there, or something of that nature. And that'll cut mustard. But I think it takes a lot more than that, which is, these defenses are useful, but they can be hard to win. Chris, we have a couple minutes.
Don't joyride the forklift off the end of the loading dock. That would be a more concrete example.
There you go. Chris, did you want to touch on the O'Rourke case quickly, or you want to move on to questions?
No, I'll try and do it quick. Just because it's an interesting fact pattern. This was back in, I think, 2016 or 2015, this case came out and everyone was talking about it. It made the newspapers. We had a mother was employed by the son, and because as a home health care provider, because the son had significant health issues due to a long history of drug abuse. And I think, I've had cases in the past where I've had people that are, there's a disabled person, whether it's a quadriplegic or someone that has health problems, and they have to get someone to take care of them. And technically the person who is either, a quadriplegic, or in this case, someone that is has these health problems, is actually the employer, and they buy insurance from the state. So that was the case here. The son was so bad that he actually had to move back in with, this was an adult son, had to move back in with the mother so the mother could take care of him. In the middle of the night, one night, he attacks the mother with a kitchen knife. And the mother is seriously injured. She files a workers' compensation claim trying to allege a business relationship between she and her son. So she seeks workers' compensation benefits. The workers' compensation judge level, they find that this was a compensable injury, that there was an employment relationship, and workers' compensation benefits were awarded. An appeal is taken. It goes to the Workers' Compensation Appeal Board. The Workers' Compensation Appeal Board reverses, saying that this was not a work-related injury, that this was not during the course and scope of employment. She was sleeping at the time, and ultimately the case was appealed to the Commonwealth Court. And here's where it gets interesting. The Commonwealth Court pulls out this rule from I think it was from the 1920s, the bunkhouse rule, saying that the nature of her employment required her to be staying there. It was her own house, but required her to be sleeping at the place. So therefore, she was within the course and scope of her employment while she was there sleeping. And the Commonwealth Court developed this long decision based upon the bunkhouse rule, and ultimately overturned the board's decision and said that this was a compensable claim. This was ultimately appealed to the Supreme Court. The Supreme Court granted aliquotter and took the case, and they ultimately, again, reversed the Commonwealth Court, went back to the board's decision and said, no, this is not a compensable injury. The claimant, by the nature of her job, did not need to be sleeping in the same place as her son. The job did not require 24-hour care, so it did not necessitate her to be there while sleeping. It just so happened that they slept in the same place. The court overturned it, saying that you're not within the course and scope of employment while you're sleeping. So this is aside from the fact that we have an interesting fact pattern, we have the courts going back and forth on their interpretation of this and how they view course and scope of employment. This fact pattern likely won't show up again. So the law itself doesn't necessarily give us something that we can keep using as we litigate cases, but it just shows the nature of the court's views of these types of course and scope and how it's unpredictable as to how they view it. Both the Commonwealth Court case and the Supreme Court case had dissenting opinions, and it's an example of the only certainty here in course and scope cases is there's uncertainty, and as we indicated earlier, we can find case law to support either side, and that's what needs to be remembered when we encounter these cases, and a determination needs to be made whether or not to voluntarily accept it or deny it.
Yeah, it's an interesting fact pattern, which is always fun. Even talking about sleeping can be interesting in this scenario. We do have, I think that's the conclusion of our official program, but we have a couple questions that I want to get to. I would encourage everybody, if you're not, you don't have to run off right away, stick around for the questions. Hopefully we can do it in maybe 5 minutes, because sometimes when somebody else asks a question, it touches on something that you might have been thinking about or something in your caseload. I have the questions up in front of me. I'll try to rip through them from simple to more complicated. Somebody asked about contact information for follow-up. I just put my email in the chat. You can email me. I probably won't be able to answer your question if it's about, registering and that sort of thing. But if it's a legal question, we can certainly, I can rope in Chris and Rob, and we can take a stab at it. And I can forward you to the people if you want a copy of the seminar, that sort of thing. I can forward your email along. So my email's in the chat. Chris, you talked about recreational activities. The question is, would a waiver help if your employees are engaging in a recreational activity, a waiver for the company picnic or the softball game?
Well, I think it's still going to come down to control. I think a waiver probably wouldn't hurt, but I really think that it still comes down to control. I've seen waiver. I've had cases where claimants signed documents saying that they did not sustain a work-related injury and then ultimately file a claim petition. We litigate the case and lose. So I think that it's tough to waive away an entitlement to benefits, just like technically you can't waive away an entitlement to receive unemployment compensation. I don't know that you can waive a legitimate entitlement to workers' compensation benefits.
I think, and Rob, you can weigh in on that. I think that I agree with Chris. It's for the comp claim. I think a waiver is more difficult. You might be able to waive away, obviously if you're the company that runs the picnic, if you go to an amusement park, they might be able to get a waiver for a third party case. But I think in the comp arena, it's difficult to have an employee waive away potential work injuries, because otherwise, Rob, we would do that with all of our employees the day that they start working there.
Yeah, I agree with you both. I don't think that you can waive entitlement to workers' compensation benefits, even if it's outside of the normal course and scope, and it's a company sponsored picnic. I do agree with Chris that it's along the same lines that you as an employee technically cannot be required to waive entitlement to unemployment compensation benefits, or at least to apply for unemployment compensation. So I think the waiver would be difficult to enforce or show that in some way removed the employee from the workers' compensation context. I would also have some concern that if the waiver, and this is just a spitballing, right? But if the waiver was enforceable, does that then remove the employer's shield for workers' comp claims, and then would allow the employee to sue for a tort against the employer? Just us being lawyers, but that's something that came to mind that I would have a concern about if the waiver was in some way enforceable.
I don't know if it was Rob or Chris who talked about personal comfort doctrine. There's a question about lunches, and essentially I think the question is getting at, when is lunch not going to be within the course and scope, part of the personal comfort doctrine? Does it matter if the employee checks out before they go to lunch, that sort of thing? One of you want to touch on that?
I think we both talked about it to some extent. From my perspective, if the employee is clocked out and is off premises, out of the control of the employer, I think that clearly removes them from the course and scope of employment. I think it's a gray area, even if the employee is technically off the clock, but walking to the car or driving the vehicle off the premises, but not yet onto public property or public roads. I think that would still be arguably within the course and scope. And I think one step further, if the employee is on the clock, I think that's another factor that would support, especially if they're still on the property or walking to the car, that the employee is not out of the course and scope of employment.
Yeah, it's a good question, and I think it's going to become a bigger issue to some extent. And it's not our topic here today, but we have a lot more people working from home now, and you're on a conference call with one of your clients, and you're also making spaghetti. It gets into all that stuff that I think we actually did another seminar on, but it's not going to get any simpler with the changing workforce. Did you have anything on that, Chris?
Yeah, as you alluded to earlier, Jason, I mean, there's case law specifically addressing both sides of this that, when we were looking at it earlier today, it's almost difficult to differentiate between the two. And I was recently asked by a client, and it never went into litigation, but it was asked me to address whether or not a situation, and it was a sad situation, an employee was on their lunch break, brought their own food, choked on it while at work, while on the premises. The Heimlich was attempted, it didn't work. The person ultimately died. And I was asked to determine whether or not it was, we had any defenses to it. And ultimately looking at the case law, the recommendation was that this was a compensable claim, primarily because they're on the premises, and that's going to be a large factor, as well as Rob alluded to, whether or not they're on the clock or not on the clock. So, I mean, those are going to be the factors with lunch.
Chris, we had a coming and going rule question about a home health care worker. And I think in the scenario posed by the participant, this home health care worker has one client. So they have one person that they go out and work in their home and provide assistance. And then obviously after they're done with their shift, they go back to their house. Does the coming and going rule apply in that situation?
Well, I think that you make the argument in the litigation that this person is a stationary employee. They have one fixed place of work. And, that's going to be a factual distinction for the judge, and they're going to argue that they're not. But ultimately, if they have one client and they're going to one place every day, it's going to be hard to argue that they're not stationary employees, even though typically home health nurses, are considered traveling employees. So that is the argument. And I would strongly make the argument that the coming and going rule applies, and that any injury sustained during the travel to or from or the commute would not be compensable. I had a case once where the job title of the person was traveling manager. All they were it was for a chain of tire stores, and whenever a manager would be on vacation, this person would fill in. So for a week at a time, they had a fixed place of employment, but their job title was traveling manager, and that was something that we had to litigate. And ultimately we settled the case, so I never heard how the judge decided, but that would have been a very interesting one. It probably would have been appealed up to the higher courts, regardless of how the case would have come down.
Okay. I got two more questions. I'll take the first one myself. Letting the tour bus driver answer questions, this could always be a mistake. So I'll let these guys catch me if I fall. It's a traveling employee who was in a car accident. And the situation here is the employee was on their way. They were coming back from a location where they occasionally go. So it could be, we'll just use the home health care worker who goes to more than one location. And this is the location where the home health care worker occasionally goes, but it wasn't on their docket for the day. So it sounds like in this situation, the employee gets a list of locations to go to. Here's your 5 locations. And they checked in on a 6th location. After traveling back from that 6th location, they're in a motor vehicle accident. How would course and scope be interpreted in this case? My answer is I'm not, and I know it has evidentiary value, but I'm not going to be fixated on the docket or the employment, the list from the employer of locations you go to, if the claimant can testify persuasively that there was leeway there, that they were supposed to check in on these other clients or go to these other locations. I think it's going to be very evidence specific. I think that if the judge thinks that this claimant has some leeway, some opportunity to stop at these other locations, then I think the judge is going to find a compensable injury. I think if it's very clear through the evidence that the claimant was just supposed to go to the locations on the list, then you might be able to get out of the compensable injury. Do you guys disagree?
I agree.
I agree as
Good
well.
answer.
Well done.
Rob, one for you. We'll give you the last one. The great thing about these questions is I think every time I misread the question and ask the wrong question, but that's okay. It provides discussion and maybe it helps somebody else. The question here is about a employee who's interacting with an outside vendor and they get into a dispute. The employee goes after the third party, which is the outside vendor, and they get into a road rage type of situation on the company premises. So I'm guessing the parking lot. They're playing bumper cars in the parking lot because they're angry at each other. The employee ends up being, and this is where I think, Rob, you can speak to. The employee was terminated for violation of company policy. He's now saying he hurt his leg during the altercation. Rob, can you imagine a scenario with those facts where it is a compensable injury? Obviously, it sounds crazy that they're running into each other in the parking lot, but could that be something that's compensable?
Well, I think that if I got that email or call, one of the first things I would ask is what was the context of the disagreement? If the context of the disagreement had something to do with the vendor's improper delivery of whatever the employee was receiving, or if there was a dispute as to pricing and that was something the employee was responsible to handle, I could see how that would theoretically bring it into the course and scope, where the disagreement and the ultimate road rage is a result of something related to the employee's furtherance of the business affairs or within the course and scope of the employee. If however the vendor didn't like the employee's shirt that the employee was wearing that day, and the employee took offense because everyone should like a peach colored shirt, that would not be within the course and scope, I would argue, because the dispute and the ultimate road rage and alleged injury has nothing to do at all with employment or with why the vendor was on location. So I think the first thing I'd want to know is what are the details surrounding the initial altercation, and that goes right back to the first thing Chris said when we started today, is to document as much as you can to preserve that time capsule for the future. Because if the argument was completely unrelated to employment, I don't see I would argue there wasn't a work-related injury.
Reading the question again as you're talking, Rob, I think another factor there that might come from it, let's say the dispute is about something work-related, your widgets are of crappy quality, and we don't want to buy your widgets anymore, vendor. And the vendor says, well, you're just a terrible person. Goes out into the parking lot. Our employee, this is our claimant, follows the vendor out into the parking lot, and they initiate the altercation. They initiate it's personal animosity about work. They're fighting over the widgets, but our claimant is the aggressor in the situation. Does that help the employer? It sounds like it should.
Well, if the employee attacked the vendor and that would result in a misdemeanor or felony, I think I would also argue that it was a violation of law. The employee should not benefit from an alleged work injury if he beat the heck out of the vendor and is going to be charged with assault. So I would investigate that, as well as to a possible defense of the claim in its entirety. The question also, I think, had a component about termination for a violation of company policy. So even assuming there was a compensable injury, and so let's say the employee has modified duty restrictions, and the employer would be able to provide ongoing modified duty, but for the violation of company policy, I would raise the defense that while there may be a medical component of the claim, the employee shouldn't be entitled or isn't entitled to wage loss benefits, because the the cause of the wage loss is not the work injury, but the cause of the wage loss is the violation of company policy for which he was terminated.
Awesome. Yeah, as we're going through this, I probably should have taken the contact information question last, because this is a bit of a downer note to end on. I don't want anybody going out and fighting each other in the parking lot to test the bounds of course and scope. But thank you guys. This was fun. This was we went over an hour, and I thought it went quickly. And I want to thank everybody that hung on. We pretty much everybody stayed on the call on the conference, so that was awesome. If you have any questions, shoot me an email. Chris and Rob's information's probably going to be on the follow-up email. If not, it's on the website. We have another one of these coming up in 2 months on claim petitions, and we hope everybody's having a great summer.